Okay, Stella, is your client around? Is your client in court? This is Stella. You are muted. You should unmute yourself. You are muted.
Bala, can you hear me?
Yes, I can hear you. Is your client in court?
She said she will be around. I'm seeing one, some
It's
of
okay,
these
it's okay.
names.
It's
They don't
okay.
repeat their names.
It's okay.
And Lillian, are you there?
It's okay,
I don't know
Clement.
whether she,
Please,
I don't know
Clement
what
absent. It's a simple something. Clement absent, please. You don't need to.
No, she's present. She said she called me just a few minutes ago.
Where is she? Where is she? Where is she?
Okay, she's absent because I'm not seeing her.
Whether she's here or not here, you are here. Please announce your appearance. Okay, defendant absent. Announce your appearance, please.
May please, my lord, announce appearance for the claimant. My name is Stella John.
Yes, Mr. Ambrose.
Yes, may please, Honorable Court. Ambrose Onyemakono, I appear for the defendants.
So this is my judgment. I'm sorry, I have kata. The claimant commenced this suit by way of complaint and other accompanying processes on the 27th of July 2018 and by an amended statement of fact dated 6th of February 2020 and filed on the 7th of February 2020, asked for the following reliefs against the defendant. Number one, a declaration that the summary dismissal without more by the defendant.
Your phone is blocking your face. I'm not seeing any of your face, my lord. I'm so sorry.
Do you need to see my face, please?
The phone is blocking your view. I'm not seeing you at all.
You need to see my face.
Yes, my lord.
You need to see why?
Because the audio is poor. So like from your mouth, I can hear what you are saying.
A declaration that the summary dismissal without more by the defendant against the claimant after about 20 years of dutiful service is unconstitutional, unlawful, illegal, null and void of no effect whatsoever, has been in gross breach of natural justice and the terms and conditions of service as per defendant's employee handbook. Number two, a declaration that the claimant is entitled to all her salaries and other entitlements due to the passing of the claimant from August 24, 2007 to October 20, 2009, the period of frozen and not access salary account. Number three, a declaration that the claimant is entitled to all her salaries and other entitlements due to the passing of the claimant from August 21st, 2008 to the period of reinstatement. An order directing the defendant to reinstate the claimant to the service of the defendant bank. Number five, an order directing the defendant to pay to the claimant all her salaries and other entitlements due to the passing of the claimant from August 24, 2007 to October 20th, 2008. The period of frozen and not access salary account 15 months, the sum of 2,319,000 naira, 866 naira 55 kobo. Number six, an order directing the defendant bank to pay to the claimant all the arrears of her salaries, and other entitlements due to the person of the claimant from an order directing the defendant bank to pay to the claimant all the arrears of her salaries and other entitlements due to the person of the claimant from October 21st, 2008 to the period of reinstatement at the rate of 1.9 million naira per annum. Number G, an order directing the defendant bank to pay to the claimant the sum of 50 million naira in general damages to cushion the effect of the emotional trauma and untold hardship the claimant has suffered, and she has been suffering since October 2008. Number H, an order directing the defendant bank to pay to the claimant 2 years annual leave allowance, 550,000 naira per annum, and as reflected on the increment letter. Number I, an order directing the defendant bank to set in motion relevant processes that will release to the claimant all the mandatory contributory funds hitherto in the name and favor of the claimant from Federal Mortgage Bank, but those funds are totally for the housing benefit of the claimant, absolutely. Number J, an order directing the defendant bank to release and surrender to the claimant her first bank share certificate number 4879638, which started operating from 2007, which share certificate has since October 2008 been in custody / power of the defendant. Number K, the cost of this action. Number I, interest on the judgment sums at the rate of 11% per annum until debt is fully liquidated. Alternative claims, they are there. I don't need to reproduce them. The defendant, in reaction to the claimant's suit, entered appearance and filed a statement of defense on 26th of November 2018 via a motion for extension of time to that effect. The defendant also filed an amended statement of defense on 26th of February 2020 in consequence of the claimant's amendment. Meanwhile, the claimant filed a reply to the statement of defense on 11th of December 2018. On the 19th of December 2018, the defendant filed a notice of preliminary objection to the claimant's suit, but was overruled by the court on 10th of October 2019. Test of the claimant. From the pleadings filed by the claimant and her testimony, she was employed by the defendant on 22nd of August 1988 and had been in the said employment until her summary dismissal on 21st October 2008. That even though she did not proceed on her 2006/2007 annual leave owing to exigency of duties, but the defendant never paid her 2006/2007 annual leave to the tune of 555,000 naira. Claimant also advised that while working at the defendant's branch at Alaba International Market, she discovered a computer posting of 3 million naira into a teller cash account made by the cantonment agency manager, Mr. Julius Fabayo. But the manager could not justify his action when he was queried in 2007. It was also about that the claimant was being victimized because after she and Mr. Fabayo were released from detention by the police, they were placed on indefinite suspension. That 7 months after the incident, they were invited to appear before the defendant disciplinary committee, after which her salary account could not be accessed, but that of Mr. Fabayo could be accessed. Claimant stated that all her pleas for lifting of her frozen salary account were turned down. It was stated that the defendant has frozen her salary account between August 2007 and October 2008, which has the balance of 2,319,000 naira. According to the claimant, while Mr. Fabayo's appointment was terminated, she was summarily dismissed after 20 years of service without benefit. Claimant further about the subsequent discussions and negotiations through her counsel, which with the defendant even after the mediation process at Lagos State Office of the Public Defender to rescind the defendant's decision failed. Case of the defendant. The case of the defendant is, however, that on 24th July 2007, its fraud and investigation unit was notified by the Alaba branch that the claimant was discovered to have suppressed cash to the tune of 3 million naira and fraudulent withdrawals from several customers to the tune of 3 million naira, leaving the total sum involved at the sum of 6,112,000 naira. Defendant further stated that having seen so many fraudulent activities carried out by the claimant, the defendant followed due process by suspending the claimant with half pay basic allowance while she enjoyed full payment of her other allowances. The claimant was queried, suspended, and was invited to the disciplinary committee where explanations were duly considered. According to the defendant, it found out that the claimant was culpable of official gross misconduct to it, cash suppression, and fraudulent withdrawals from customers' account in breach of the code of conduct expected of the staff of the defendant as contained in his handbook, hence her summary dismissal. It was advised by the defendant that in dealing with the claimant's gross misconduct, it had to refund affected customers to the tune of 6,112,000 naira in order to avoid bad publicity the story would generate and possible lawsuit from the affected customers. The defendant also stated that all the allegations of the claimant are not true and that the claimant was not at any time prior to her summary dismissal recalled from suspension. And neither was she exonerated of her gross misconduct case in suppressing cash and meddling with customers' account howsoever. The defendant also averred that the claimant is not entitled to any leave allowance for the year 2006/2007, having failed to comply with the bank's procedure for proceeding on annual leave as prescribed in the staff handbook. Trial commenced de novo before me on 8 June 2001, where the claimant testified by adopting her two witness statements on oath dated 11th of December 2018 and 7th of February 2020, respectively, and tendered the following documents as exhibit C1 to C25. Claimant was thereafter cross-examined by learned counsel to the defendant on 25th November 2021, and a case was then closed. The defendant opened its case by calling a sole witness who adopted her witness statement on oath dated 26/10/2020 and tendered the following documents as exhibit FB1 to FB5. The defendant was thereafter cross-examined by learned counsel to the claimant and was re-examined, and the case of the defendant was then closed, and the matter was adjourned for adoption of final written addresses. The defendant's final written addresses dated and filed on 18th of July 2022. A loan issue for the termination was submitted to it, and I quote, whether given the facts and circumstances of this case, the claimant was not rightly and properly dismissed by the defendant, and whether considering the totality of evidence, oral and documentary, this honorable court ought not to dismiss all the relief sought by the claimant in their entirety. And counsel for the defendant submitted that the burden placed on the claimant in this suit is heavier, given the nature of her main claim, of her main reliefs 1, B, and C, and alternative reliefs M and N, which are declaratory reliefs. That the law is that a claimant who seeks the declaratory reliefs will swim or sink based on the strength and weakness of his case, citing the case of Wema Bank Limited and Arison Trading and Engineering Company Limited. That based on the oral evidence and materials placed before the court, it is crystal clear that the claimant has failed to discharge the burden of proof placed on her. Counsel also submitted that it is the duty of an employee seeking judicial pronouncement that termination of his employment is unlawful and or wrongful to prove his claim by credible evidence. That the claimant must at all times succeed on the strength of his case in a claim for wrongful dismissal. citing the case of Borishadi and Nigerian Bank of Nigeria Limited. Council further submitted that to decide the burden that the summary dismissal of the claimant is unconstitutional, illegal, and unlawful, the claimant needs to establish, one, that the constitutional provisions that were all were breached, the statutory provision that was violated, and the specific terms and conditions of service as per defendant staff handbook that was all were breached. The Council referred the court to Article 11.4 of XBC4, titled Sanction and Offensive, and stated that upon receiving the claimant response, the defendant commenced investigation into the matter. The defendant fraud and investigation unit invited the claimant and the supervisor for interrogation on their activities, after which they were both reported to Nigerian police, who invited them, obtained their statement, and further conducted searches at their residence, during which a lot of customers' payment vouchers were discovered against the banking standard and practices. As both the claimant and the supervisor could not explain the reason why they had such number of the defendant customers' vouchers in their private records and premises, that by a memo dated 24th August 2007, XPC7, the claimant was placed on suspension would pay till the conclusion of investigation in compliance with XPC4. And again, by a memo dated 4th February 2008, the claimant was invited to a meeting of the Business Development Office Disciplinary Committee, which held on the 6th of February 2008. And upon the conclusion of investigation, the claimant was found liable for fraudulent practices bordering on dishonesty, stealing, and unprofessional conduct as a banker, and was summarily dismissed for violating the terms and conditions of employment as captured in XBC4. The Council stated that XBC4 allows an employee who is sanctioned to appeal the decision to head office disciplinary committee within 3 months of receipt of the letter of sanction, and thereafter such appeal becomes time barred. That the claimant did not present any appeal to the head office disciplinary committee within 3 months of a summary dismissal. The claimant subsequently caused a letter to be delivered to the defendant on 4th February 2009, which period exceeded the maximum time allowed for appeals. It was also stated that although the claimant has failed to prove her allegation that she was unlawfully or wrongfully dismissed, and the burden never shifted to the defendant, Council nevertheless demonstrated the fact that the claimant's claim of unconstitutional, unlawful, illegal, and wrongful dismissal is spurious and lacks merit. It was argued that in a claim for wrongful dismissal, all the defendant needs to show is that the allegation was disclosed to the claimant was given fair hearing, and the disciplinary appeal and disciplinary panel followed the laid-down procedure, if any. Council referred the court to the case of Federal University of Technology, Yola, and Moya. It was argued that there's no dispute that the offenses for which the claimant was dismissed were disclosed to her. Council referred to the cash shortage query, Exhibit 10, by which the resident internal control officer of the defendant relayed findings regarding disparity in the claimant's record to her on the alleged discrimination and victimization stated at various paragraphs of the claimant's pleadings. Article 1 of International Labour Organization ILO Convention concerning discrimination in respect of employment and occupation, 1958, was referred to that by the ILO Convention, the claimant in the minimum has to show how she suffered any discrimination, exclusion, or preference on the basis of race, color, sex, religion, political opinion, traditional preference, or social origin, which impaired equality of opportunity or treatment during her employment with the defendant. This onus has not been discharged given the evidence before the court. Furthermore, despite alleged discrimination and victimization on the premise that her erstwhile supervisor was allegedly paid terminal benefits following the termination of his employment while she was dismissed, the claimant failed to provide proof of her allegation in this regard. Counsel submitted that to prove this allegation, the claimant needs to prove that she was investigated for the same disciplinary issues as the said Mr. Fabayo, and that Mr. Fabayo was paid his terminal benefit. Counsel submitted with regards to the first issue that the claimant has failed to show to the Honorable Court that Mr. Fabayo was investigated and faced the same disciplinary issues as herself, as the memo dated 7th August 2008, Exhibit 7, will bear out. The said Mr. Fabayo was subjected to disciplinary proceedings for his failure to exercise supervisory role over the claimant, which paved the way for the claimant to commit the fraudulent practices she was found to have committed. In other words, Mr. Fabayo's offense was failing to carry out his supervisory duty with regards to the claimant. From Article 11.3 and Article 11.5 of the Defendant Handbook, there is a clear difference between a person carrying out fraudulent acts and another who fails to carry out their duties to supervise a person who has committed a fraudulent act. The determination of Mr. Fabayo's employment was in compliance with Article 11.3, while that of the claimant was pursuant to Article 11.5. Given the distinction and the offenses for which the claimant and Mr. Fabayo were indicted for, it only makes sense that there is a different outcome, and the clear evidence before this Honorable Court is that the outcomes align absolutely with the sanctions agreed in the Defendant Staff Handbook. Counsel maintains that further to the above, the claimant failed to prove that Mr. Fabayo received any terminal benefit as alleged, and in fact failed to plead or give evidence of what constitutes terminal benefit as alleged. Till submission of counsel on the alleged blockade of the claimant's salary account and material contradiction, that the claimant in her solicitor's letter dated 27th of January 2009, Exhibit 13, stated that she withdrew from this account on 26 September 2009, a period she claimed the same amount was blocked. Counsel referred the court to the case of Markan and Hangem in respect of inconsistent evidence. The counsel contended that on the totality of the evidence before the court, as contained in the claimant's pleadings, the claimant has failed to prove her entitlement to the reliefs being sought. Counsel further contended that the evidence that the claimant was suspended with half pay was in compliance with the staff handbook, and the claimant has failed to show that suspension was in violation of the terms and conditions of her employment. That by Article 11.4d of the handbook, only employees who are exonerated at the end of the investigation are entitled to the balance of the basic salary and other entitlement. In the claimant's case, she was not exonerated and was summarily dismissed. In the circumstance, the claimant is not entitled to be paid the balance of the basic salary, having been found liable and consequently dismissed for fraudulent conduct. Furthermore, the claimant's reference to other entitlements is a claim in vacuum, failing to identify the specific items that constitute entitlement, thereby making the relief speculative. Now, the law is clear that the court will not dwell on speculation and will rather act based on evidence. Or if C claimed by the claimant that she is entitled to all her salaries and other entitlements due to her from 21st October 2008 to the period of reinstatement. It was argued that salary is meant for serving employees and not dismissed employees. That the claimant having been summarily dismissed for gross misconduct is not entitled to salaries for this period, citing the case of Kule Asinsanya and AfriBank Nigerian PLC. For a LFD, which is an order for reinstatement, it is a submission of counsel that it is straight law that reinstatement is not an option for the manner of contract between the claimant and the defendant. More so that the claimant's employment was validly terminated by the defendant in compliance with the terms and conditions of employment contained in Exhibit C4. Furthermore, it is also stated that the court will never force a willing servant on an unwilling master, citing the case of Malok Abedin Corporation, Malok and Abedin Corporation. Counsel cited the evidence before, stated that the evidence before the court shows that the claimant is not entitled to damages in any sum. As such, she is not entitled to 50 million naira claim as claimed in her Relief G. That the claimant herself shows that her summary dismissal followed due process and is not howsoever wrongful. Also, there's no evidence before the court that the claimant suffered any emotional trauma and untold hardship at the instance of the defendant. Counsel also stated that, assuming without conceding that the claimant's summary dismissal was even wrongful, in a claim for wrongful termination, as in the instance case, the normal measure of damages is the amount the employee would have earned under the contract for the period the employee could lawfully terminate. That is the quantum of damages, and the court will not award general damages, such in the case of New Nigerian Newspaper Limited and Atoibi. The counsel submitted that reliefs I and J are incompetent in law and unsupported by fact before the court, especially the claimant's admissions. That the law is clear that what is admitted requires no proof. In the circumstance, counsel urged the court to dismiss reliefs I and J of the claimant, having admitted that they are both unfounded and incompetent. For the claim for cost and interest, counsel submitted that given the evidence before this court, no occasion or event has arisen to warrant the award of cost in any sum or interest of any percentage in favor of the claimant. Counsel submitted that with respect to salaries, the clear evidence of the claimant before this honorable court is that she was paid half salary for the entire period she was under suspension until she was summarily dismissed. Evidence is also clear on the fact that the claimant had access to her salary account and did in fact withdraw, contrary to the allegation that she did not have access to the said account. Counsel further submitted that with regards to monthly pensions, gratuities, and other allowances, there is no factual basis to support these claims, given the pleadings and the evidence before the court. As a matter of fact, there was no mention of unpaid pensions and entitlement to gratuity in the entirety of the claimant's 64-paragraph statement on fact and 65-paragraph statement on oath. That the law is clear that evidence must be laid on facts pleaded, and it follows that where neither the pleadings nor evidence supports a claim, the same cannot be entertained by the court. Citing the case of Reptico S.A. Geneva and Afribank PLC. Counsel contended that the claimant's reliefs R, S, T, U, and V are mere duplications of reliefs G, H, I, and K, which have been adequately addressed earlier. Counsel urged the court to dismiss all the claimant's reliefs. Claimant's final written address. Claimant's final written address dated and filed on 12th of August 2022 contains 4 issues for determination to which. Number 1, whether the defendant bank has been able to justify the reasons for dismissal of the claimant. Number B, whether the claimant is entitled to all the relief sought in this suit as spelled out in the amended statement of fact. Number C, whether the defendant was recalled after suspension. Number D, whether the defendant has the power to place a hold on an employee's staff account on court. Learned counsel argued on issue 1 that in civil proceedings, the burden of proof shifts to the defendant in certain circumstances who must discharge the burden as against the submission of the defense counsel. Citing section 133 sub 2 of the Evidence Act, section 133 of the Evidence Act was cited in 8, that the issues of allegation of fraud by the defendant and dismissal are exception to the general rule of burden of proof, which the defendant bears the burden to prove. Citing also section 135 of Evidence Act. Counsel submitted that the burden placed on the claimant in the instant case, as per the case of Kato and CBN and Amadou and Amedu, was discharged by the claimant by pleading and front-loading her letter of employment and employee handbook, which contained the terms and the terms of the contract, which were breached by the defendant. Learned counsel also submitted that by Exhibit C25, the defendant submitted that by Exhibit C25, the defendant alleges a shortage of 2 million naira following a revealed till of physical cash of 12 million naira, and requesting an explanation. And in response, the claimant submitted to the defendant Exhibit C10 that the claimant connected the imbalance of account to the notorious bank customer system, notorious bank computer system failure throughout the months of June 2007. Claimant stated that on noticing the fluctuations in the account, she alerted her boss, who was the only officer with her in the cantonment agency of the bank. That she also communicated the unusual development to the overall branch manager at Alaba International Market branch, but efforts at reconciliation of figures failed. Hence, complying with clause 3 on page 4 of her letter of appointment. The Learned Counsel stated that it was the claimant who discovered the cash shortage during the system breakdown, that she played key role in resolving the difference, but to no avail. That in general banking practice, the fact of discovery of shortage or difference in treasury balance does not translate to fraud. Cash account is not open to everybody, but it's made of treasury figure. ATM balance is still balance for the cashier. The claimant pleaded that she discovered a strange posting of 3 million naira into a teller account by Julius Favayo, her boss, which she could not substantiate. The Learned Counsel submitted that the defendant alleged that some of his customers' vouchers were found in the residence of the claimant, but there is nowhere in the pleadings that the said vouchers are front-loaded or listed. It is strict law that failure to produce the document by the defendant raises the presumption that, if produced, they would have been against the defendant in whose possession such documents are, citing sections 167D of the Evidence Act and the case of Adeola and Alobo, Abba and Jumari. It was submitted by counsel that Article 11.5 of the Employees Handbook on summary dismissal, an employee becomes summarily dismissed on proving cases of theft, fraud, dishonesty, defalcations, irregular practice in respect of cash, vouchers, record returns, customers' account, or foreign exchange transaction, and hence failure to report promptly any irregularity on the part of any employee after having knowledge of such irregularity. That a pertinent question is, who investigated the fraud? Was the fraud proven as provided by the handbook? What were the findings revealing the particulars of fraud? By corporate practice, investigation ought to have taken place consequent upon which query would issue. That query cannot be based on speculation. It is submitted that there's nowhere in the pleadings where any report of investigation was mentioned or front-loaded. That exhibits 7A and B, which is alleged to be a disciplinary report, is inadmissible by virtue of Order 40, Rule 1, Sub-Rule 3 of the rules of this court, which says that unless the court for special reasons at all before the trial, otherwise orders or direct, no document, plan, photograph, or model shall be receivable in evidence at trial of an action unless it has been filed along with the pleadings of the parties under these rules on court. It was argued that what is not pleaded goes to no issue. There is no document as Exhibit 7A and B listed to be relied upon at the trial or front-loaded at all. It is on record that from the court proceedings are records at all material times. Neither the claimant nor her counsel nor this court had an insight into Exhibit 7A and B. The Learned Counsel submitted that the law is that an employer must give valid reasons for dismissing an employee and also afford the employee a right to be treated fairly and given the opportunity to defend himself, as this carries a stigma on the dismissed employee. That in the case of Union Bank PLC and Sores, Judge Abomeli and Nigeria Railway Corporation, that where the defendant pleads fraud and does not depose and exhibit particulars of fraud, it goes to no issue. It was also argued that the response to query Exhibit 10 connects the defendant's computer system failure to a disruption in the system entries, leading to some strange differences, but there is nothing that the defendant management performed its duty to investigate the system failure to ascertain the veracity of the claim of the claimant in a response to the query. citing the case of High Grade Maritime Services Limited and First Bank of Nigeria Limited. Counsel argued on the unfair treatment of the claimant that she was not treated fairly as demanded by Article 4.9c and 11.4 of XBC4 and the case law. While investigations were ongoing and not concluded, Julius Fabayo was retired with benefit, but the claimant was summarily dismissed after 20 years in service. That Article 10.4c provides that an employee shall be summarily dismissed on finding of guilt for gross misconduct, but does not report of guilt consequent upon concluded investigation placed before this court all material times. Yet the defendant dismissed the claimant that while her account was discriminatorily frozen after she made a withdrawal from her account on 26th of September 2009 and has remained frozen till date, but that of Julius Fabayo was unfrozen, and the claimant's pleas in her letter for the defendant to investigate the discriminatory freezing of her account fell on deaf ears. Claimant referred to Exhibit C5, which inferred discrimination against her. Exhibit C70 was also cited that the actions of the defendant offend Article 111 of ILO Convention, which expressly prohibits discrimination. Issue number 2, whether the claimant is entitled whether to in this spelled out in the assessment of fact. Counsel contended that having shown from Exhibit C1 and C4 how the natural justice for all damage would have been if there had been no breach. Sahara Energy Resources Limited on issue 3, it is a solution of counsel and with the literal canon of construction of documents and all statutes. What is paramount in any document is the words used in communicating the intent and purpose of the literal sense. That by Exhibit C7, claimant went on suspension, and by Exhibit 24, she was absorbed back into all-day banking 12. Counsel referred to Article 11.4 of the dependent of the handbook on suspension, and all the court to infer from the evidence adduced that the claimant was factually recalled to work from suspension, and this was not a surprise to the claimant because during the period or prior to the recall, there was no report of any fraud. Issue 4, counsel admitted that both from the pleadings and testimony of defense witness The claimant and one Julius Favayo, the boss of the claimant, were accused of fraud. Julius Favayo's account was opened as per paragraph 38, 35, 38, and 42 of the amended claim. He was retired with benefit and placed on pension as per paragraphs 43 and 44 of the amended statement of fact. Thank you. It was submission of counsel that claimant's account was frozen and has been closed for the past 13 years in violation of paragraph A of Article 1.4 of the handbook. Submission of counsel that it is strict law that no customer's account can be frozen except on the strength of the court order. Counsel started the case of GTB and Joshua. Legal counsel for the claimant finally urged the court to grant all the claimants' reliefs. Reply on points of law. The defendant filed its reply on points of law on 5th February 2004 to the claimant final written address dated 12th August 2022. In response to the claimant's final written address, counsel contended that the claimant's counsel misapprehended the law as it relates to the power, as it relates to the proper approach for dismissing an erring employee. That the correct position of the law is that the court cannot delve into the issue of whether the employee was guilty of the misconduct, nor can the court reinvestigate to determine the level of culpability of the employee in the said misconduct. These are not within the province of the jurisdiction of the civil court. The Court of Appeal put the correct position very aptly in the case of Yusuf Umar Gunda at the University of Maiduguri. Counsel therefore urged the court to discountenance all the submissions of the counsel, placing any burden on the defendant to establish fraud beyond reasonable doubt or to establish the guilt of the claimant before this honorable court. Another counsel submitted that what is an issue is whether the claimant dismissal was done in breach of the terms of the claimant employment or the laws of fair hearing, and this issue has been sufficiently addressed in paragraphs 3.14 to 3.116 of the defendant's final written address in such a manner that showed that the claimant dismissal was in line with the terms of her employment and the principles of fair hearing. In stark contrast, the claimant failed to cite any term of her employment that was breached by the defendant in her dismissal. The other counsel also argued on exhibits 7A and B that it is certain law that failure to front-load a document does not make it inadmissible, lying on the case of Onoaha and Onoaha, Okoriafia and Agu, Oboru and Oduagan. It is submission of a counsel that the said exhibit were attended in compliance with the law of evidence and the rules of court, in that they are pleaded as the defendant pleadings contain ample allegations of fact on the disciplinary committee investigation and its outcome, that the claimant had notice of the document before the trial. It is a submission of a counsel that on the strength of the above cited authorities, it therefore follows that since these documents, Exhibit 7A and B, are reports of the disciplinary committee pleaded in paragraphs 29 and 32 of the defendant's amendment of defense they are relevant to this matter before the court, and therefore cannot be rejected simply on the ground that they are not front-loaded. That the appellate court in a plethora of cases have long settled the issue that these documents are admissible. This is my opinion. Upon careful perusal of the pleadings filed by the parties, the evidence adduced, and the submission of the respective counsel, I note that the defendant in its submission formulated a sole issue for termination, while the claimant formulated 4. But the short point upon which I will decide this case is whether from the totality of the facts come evidence before the court, the claimant is entitled to the reliefs sought. However, before going into substantive matter, let me quickly deal with some preliminaries. Claimant's counsel, when adopting her final written address, has drawn the attention of the court to the fact that she's no longer interested in arguing her reliefs 1, I, and J. Therefore, those reliefs having been abandoned are accordingly dismissed. It was further argued by the claimant's counsel that Exhibit 7A and B is inadmissible because it was never front-loaded by the defendant. The defendant, however, argued otherwise. The simple question I will ask is, can a document that was not front-loaded be tendered and admitted during trial in Donalin and Investment Limited and BGL? The Court of Appeal per Audi JCA then had this to say, and I quote, the fact that they are not front-loaded becomes something inconsequential. There is no law that says a document which was not front-loaded is inadmissible. Section 1 of the Evidence Act 2001 is to the effect that relevancy is the basis of admissibility of evidence on court. While I appreciate and note the fact that the front-loading system is an innovation under the various rules of court, which was made for the purpose of expediting trial and cushioning the effect of springing surprises, but the law remains that it is the Evidence Act and not the rules of court that governs admissibility of evidence. To me, rejecting an important document simply because it wasn't front-loaded at the right time can lead to an unfair outcome. In the instance case, Exhibits 7A and B is relevant to this case and remains admissible, as it was the outcome of the investigation by the disciplinary committee that led to the summary dismissal of the claimant and termination of Mr. Julius Favayo. The defendant has on several occasions pleaded facts relevant to the document. Therefore, the objection of a learned counsel for the claimant is overruled. The defendant has, on one hand, argued that the claimant has not complied with Article 11 of Exhibit C4, which says that an employee who is sanctioned is allowed to appeal to the decision to the head office disciplinary committee within 3 months of receipt of the letter of sanction, after which the appeal becomes barred. That the claimant was therefore time barred. In the case of Uwanko and Nigerian Army, it was held by the Court of Appeal per Amadi J, while interpreting Section 178 of the Armed Forces Act, that a compulsorily retired Army officer is not affected with the provision of Section 178 of the Armed Forces Act. See also the case of Hassan and Nigerian Army, while the Court of Appeal, in its considered decision, upheld the decision of the National Industrial Court, refusing to strike out the case on Section 178 of the Armed Forces Act. By Section 6 of the 1999 Constitution, the judicial powers vested in the court shall extend to all matters between persons or between government or authority and to any person in Nigeria, and to all actions and proceedings relating thereto for determination of any question as to the civil rights and obligations of that person. See Section 6, sub 6B of the 1999 Constitution. To me, the claimant's right to institute this action cannot be taken away by the provisions of Article 11 of Exhibit C4 in circumstances of this case. Let me quickly state that in the case of In the case of Nigerian Army and Hassan, Supra, the Court of Appeal has hinted the point that the appellants cannot raise for the first time in their final written address the issue of condition precedent under Section 178 of the Armed Forces Act without earlier raising the issue in their pleadings. I observe in this case that the defendant only raised this issue of the claim not exhausting the internal mechanism for the first time in their final written address. The issue was never raised either in the defendant's pleadings or by your notice of preliminary objection. I wish to add that irregularities either arising from defects in the origination processes or arising from failure to comply with the condition precedent is waivable at the expense of the defendant to allow the proceedings to be heard on merit. See the case of Ogoini and Nikon Insurance PLC. In the light of the above, therefore, I have no reservation assuming jurisdiction to hear this case on its merit. Having dealt with the preliminaries, I shall now move to a substantive matter. The grounds of the claimant against the defendant from the above fact in her pleadings, as earlier stated, is that she was employed by the defendant since 1988 and had been in the said employment until her unlawful summary dismissal on 21st August 2008. The defendant, on the other hand, contended that the claimant was found culpable of gross misconduct of cash suppression and fraudulent withdrawals from customers' account in breach of the code of conduct expected of the staff of the defendant as contained in its handbook, hence her summary dismissal. The law has always remained the same, that to improve the alleged wrongful dismissal, the claimant in the instant case owes the tax to plead the terms and conditions of her employment and to show how they have been breached and who has actually breached them. In the case of Idoniboye Obu and NNPC, Olurutomba and Abdulrahim. Claimant in her bid to fund her claim with a view to discharging the burden she bears, presented among others her offer of employment and a stand handbook. It must be stressed that an employer has inherent powers to discipline its employee according to contract of employment, while the contract of employment constitutes a misconduct. While the conduct of the employee constitutes a misconduct, but where such misconduct involves a crime, she cannot impose punishment like the court of law. In the case of Zainabu and Bayero University, Kano, it was held that the general rule, which is however subject to exception, is that where the dismissal of an employee is based on an allegation of a crime, the allegation must first of all be proved before the dismissal can stand. However, the exception to such general rule is that it's not in every case that an employee must be arraigned before the court of law before disciplinary action can be taken against him. Once the offense committed by the employee is within the domestic jurisdiction of the employer, disciplinary action in such a case can be taken without recourse to a criminal charge. See the case of Izoho and Task Force on Hospital Management Board, Arinze and First Bank, Yusufu and Union Bank of Nigeria. By the provisions of Article 11 of the Defendant's Handbook, it is stated as follows, and I quote: disciplinary procedure. Management reserves the prerogative to discipline hiring staff in accordance with the bank's laid down rules and regulations. The following procedure applies. A. When an employee fails to perform his work satisfactorily or commits an act of misconduct or negligence, he or she shall be given a query to explain the circumstances regarding his conduct within 48 hours. B. Further investigation may be carried out or receipt of the reply to the query. C. Depending on the gravity of the offense, the case could be referred to the head office disciplinary committee or Human Capital Development disciplinary committee or any of the regional disciplinary committees, depending on the location, grade of the affected employee. Subsequently, the employee may be let off, caution, verbally issued, caution letter, one in writing, or have his employment terminated or summarily dismissed, depending on the decision of the disciplinary committees. Article 4.10, Clause C of XB C4 also stated as follows: summary dismissal. Notwithstanding the above provision, any employee who is guilty of gross misconduct shall be liable to summary dismissal. Summary dismissal. An employee may be summarily dismissed for certain acts of gross misconduct/negligence. Such acts include A, proving cases of theft, fraud, dishonesty, defalcation, irregular practice in respect of cash, vouchers, records, returns, customers' account, or foreign exchange transaction. B, willful disobedience of lawful order or serious negligence. C, drunkenness or taking drugs other than for medical reasons, thus becoming unfit to carry out duties. D, divulging confidential information in breach of declaration of confidentiality. E, conviction for a criminal offense. F, prolonged and or frequent absence from work without leave or reasonable cause. G, fighting an assault or engaging in disorderly behavior during working hours or on the office premises or within its immediate surroundings. H, deriving any benefit in the course of his official duties. F, failure to report promptly any irregularity on the part of any other employee or non-employee after having knowledge of such irregularity. J, using abusive or insulting language or showing unruly behavior to any client, which is prejudicial to the business interest of the bank. K, any other acts of misconduct. No notice shall be given in the case of summary dismissal. In the event of summary dismissal, all terminal benefits shall be forfeited to the bank. Unquote. In the case of Arinze and First Bank of Nigeria, the Supreme Court held that in both statutory and private employment, the employer can dismiss an employee of gross misconduct bordering on crime, and it's not a requirement that he must first be tried in the court of law. That in case of misconduct bordering on crime, all that's required of the employer before the summary dismissal is to give him fair hearing by confronting him with the allegations against him and giving him the opportunity to defend himself. I need to emphasize the importance of fairness and due process in disciplinary hearing. And the key points that need to be highlighted are that the employee must be informed of the nature of the charge against him to prepare for his defense. The employee should be given the opportunity to state his case, regardless of the circumstances. And while the employee's physical presence throughout the hearing is not mandatory, he must still be given a fair chance to present his case. See the case of Onweto and UCTH. It's clearly shown and considered from the pleadings of the parties before the court and the exhibit presented that the claimant was issued a query, which he answered. Exhibit C10, C25, and C and FB2 and FBN2 and 3. C exhibit C10, C25, and FBN2 and 3. And it was stated by the claimant in paragraphs 33, 34, and 39 of her main assessment of fact that she and one Julius Fabayo were invited to appear before the disciplinary committee, which they did. It was also averred by the claimant that they are also invited before the disciplinary committee for the second time. Let me quickly refer to exhibit 7A and B, part of which states as follows, and I quote, background. The Chief Internal Auditor, in his memo dated November 8, 2007 report was received from Alaba branch that one of the cashiers attached to their cash center suppressed cash and made fraudulent withdrawals from various customers' accounts through dry posting. It was reported that Ms. Akuma's mode of operation was to make withdrawals from a customer's account without vouchers and credit the accounts of one Pastor James Eze Okoro, or take away the cash outrightly. Whenever Ms. Akuma received a complaint from any customer or observed that any customer she had tampered with the account was around, she will quickly debit another customer's account or just credit the account without cash receipt. Hence, her till was gradually depleted until the fraud was uncovered on July 4, 2007. When a cash shortage of 2 million naira was observed, cash lodgement by some customers were also suppressed by her. Some were repaid in bulk or piecemeal, while others were still outstanding at the time it was discovered. During the course of investigation, Ms. Akuma's residence was searched and police recovered lots of First Bank vouchers belonging to customers. Also recovered were deposit vouchers, which revealed that she made cash deposit into her brother's account at Union Bank and one Pastor Eze Okor's account in Coca branch totaling 1,172,000 naira. The cash deposit made into Pastor Okoro's account were usually withdrawn at Coca branch a few minutes or hours after such deposits were posted by Ms. Akuma at Alaba agency. Ms. Akuma was the cashier who defrauded many customers. She was queried on her involvement, and she confirmed that the stamp and the signature on the deposit vouchers were hers, but she could not tell or recall what happened. Mr. Pabayo was the head Alaba Cash Agency during the period under review. He failed in his supervisory role and did not detect Ms. Akuma's fraudulent act. The till account of the teller remained unbalanced for a long time without being noticed by him. More so, the till account of the teller remained unbalanced for a long time without being noticed by him. More so was carrying daily huge balances that were expected to put him on inquiry if he had timely checked her physical till against the system balance. The fraud succeeded for a long time because of the lack of supervision and monitoring over activities of the teller by him. It was also revealed in the CIA report that Mr. Favayo was not security conscious because some cash were found in cabinet rather than vault at the agency when the RICO made a surprise check on him. His excuse was that he did not want the generator to waste fuel since he finished earlier, more so it was raining on that day. BDODC recommendation. The committee established that Mr. Akuma suppressed cash and fraudulently withdrew money from several customers' accounts. It was also established that Mr. Favayo had in his supervisory role, and this paved way for the loss. Subject to ESCO approval, the committee recommended as follows. Number 1, Ms. Lillian Akuma, summary dismissal. Number 2, Mr. Julius Favayo, warning letter. HCM recommendation and comment. The case of Ms. Akuma is a clear fraud bordering on dishonesty, stealing, and unprofessional conduct. She should therefore be summarily dismissed and prosecuted to recover any outstanding amount. On Mr. Favayo, however, he was grossly negligent, and his lackadaisical attitude paved way for the fraud. We opine that the bank is better off without such grossly careless staff, who, if allowed to remain, could pave way for more colossal fraud/losses. Mr. Favayo's appointment should therefore be terminated. We therefore recommend as follows, subject to ESCO approval. Number 1, Ms. Lillian, summary dismissal. Ms. Favayo, termination. The recommendation is for the consideration and approval of the executive committee. Signed, Ayodele O. Jasemi, Head Human Capital Management. On court. It's clear from the query given to the claimant, Exhibit C10, her answer given in Exhibit C25, and the report of the disciplinary committee, Exhibit 7A and B, that the claimant was given a hearing and was confronted with the allegations raised against her. I note that the claimant, in her answer to the query, stated that the system balance was as a result of computer network failure, and that during the period of network failure, she would sometimes find her cash account in debit and credit respectively. I also note her averment in paragraph 24 of her amended assessment of fact that while at Alaba International Market branch of the dependent, she continued to check the relevant vouchers and discovered a computer posting of 3 million naira into her teller cash account made by Mr. Julius Favayo, which he could not substantiate when queried by the Alaba International Market branch. Nevertheless, the statement in Exhibit 7A and B is damning and compelling. It is shown in BDODC recommendations under paragraph 1.3 of the said exhibit that the committee established that the claimant suppressed cash and fraudulently withdrew money from several customers' accounts. It was also stated under paragraph 1.4 that the case of the claimant is a clear case bordering on dishonesty, stealing, and unprofessional conduct. The law is that where an employer dismissed or terminated the appointment of an employee on grounds of misconduct, all that the employer needs to establish to justify his action is to show that the allegation was disclosed to the employee, that he was given a fair hearing, that to state that the rules of natural justice were not breached, and that the disciplinary panel followed the laid-down procedure, if any. See the case of Unical and Asian. It was held in Joseph and First Inland Bank Limited that an employee who was confronted with allegation of misconduct before his employment was terminated cannot complain about lack of fair hearing. See the case of Udo and CSC Akwa Ibom State. In the light of the above, I dismiss the contention of the claimant that her summary dismissal by the defendant is unconstitutional, unlawful, illegal, and null and void. I see nothing in the act of the defendant of dismissing the claimant that constitutes a breach of natural justice or the terms and conditions of service as contained in the defendant employee handbook. Claimant's relief A is therefore refused. Claimant's relief C, D, and F, which are seeking for reinstatement and payment of salaries and other entitlements from the 21st of October 2008 to the period of reinstatement, are also refused. For the claim for 2006/2007 leave allowance, Article 5.4.1 of Exhibit C4, which provides for leave matters, states thus, and I quote, leave must be taken at the convenience of management during the year in which they apply. While the employer has not taken the leave due to him/her before the end of the financial year, it will be forfeited, if not taken within the first quarter of the following financial year. I see no evidence in the instance case that the claimant applied to go on leave in 2006 and 2007, and all applied for her annual and all applied for her leave allowance. As such, the claimant is deemed to have forfeited the leave allowance according to Employee Handbook C4. Claimant's relief paid for claim of leave allowance is accordingly dismissed. For the claim that the claimant is entitled to her salaries and other entitlements from 24 August 2007, when she was suspended, to 28 August 2008, when she was dismissed, it is established that the claimant was denied access to a salary account by the defendant for that period till date. It was stated by the claimant that her account was frozen and has been closed for the past 13 years in violation of paragraph 1 of Article 11 of the defendant's handbook. Claimant has exhibited her returned salary checks, Exhibit C5, and her frozen salary account, Exhibit C22, to the effect that she could not access the account. I find that the defendant was not able to controvert the averment of the claimant with respect to the freezing of her account. I think the defendant has no such right to freeze the claimant's account for 13 years. It sounds unreasonable and unfair. The claimant is thus entitled to have access to account, and anything in violation of that right shall attract damages. From the defendant's handbook, the claimant is entitled to excuse me. From the defendant handbook, the claimant is entitled to 1/2 of her basic salary and full housing, utility, and transport allowance from the date she was suspended. She was suspended on 24th August 2007 to the day she was summarily dismissed on 21st August 2008 from the defendant organization. Flowing from the above, therefore, I think claimants relief B and E are grantable to the extent that the claimant is entitled to 1/2 basic salary, and full housing, utility, and transport allowance from the day she was suspended to the day she was summarily dismissed. For the claim for damages, it was said in the case of Afolabi and Ola that general damages are only awarded where there is a breach. The law is settled that general damages are such that necessarily flow from the wrongful act of the defendant as claimed and established by the claimant, although it does not need to be specifically pleaded and proved like special damages. General damages are said to be implied or presumed from the proximate, direct, or immediate result of the act of the defendant, and that the claimant complained of the act of the defendant that the claimant complained of, and is normally granted at the discretion of the court, taking into consideration the peculiar circumstances of the case and guided by the judgment or standard of a reasonable man. See the case of Garba and Kur, Ijebu, the local government, and Adedeji, Balogun, Storms, Brooks, Balog, and Hutchison, AC, and British Transport Communication, and Goli. In the above cited cases, the principal governing award of general damages is that damages are compensation in money. They are a sum of money given to a successful claimant for loss or harm of any kind. Whilst I'm not awarding general damages for the reliefs of the claimant that have failed, but I'm inclined to award general damage in respect of the act of the defendant of freezing the claimant's salary account for 13 years, in addition to the special damages granted earlier as per reliefs B and E. All said, claimant's main case fails, but she succeeds only in part. For the alternative claims, it is tried that a main claim and alternative claim cannot be granted at the same time. Where a claim is in the alternative, the court should first consider whether the principal or main claim ought to have succeeded. It is only after the court may have found that it could not for any reason grant the principal or main claim that it will then consider the alternative claim. In other words, an alternative claim is an award that can be made instead of another. It is a separate claim and a separate award. It's not an additional award. Otherwise, it would amount to double compensation, which must be avoided. See the case of GK Investment Nigeria Limited and Nigerian Telecommunications. Consequently, the alternative reliefs are also dismissed. For the avoidance of doubt, I hereby make the following declaration and orders. For the avoidance of doubt, I hereby make the following declaration and orders. Number 1, claimants relief A, C, D, F, G, H, I, and K fail and are accordingly dismissed. A declaration that the claimant is entitled to 1/2 basic salary and full housing, utility, and transport allowance from the date she was suspended on 24th August 2007 to the date she was summarily dismissed on 21st October 2008 from the defendant's organization. An order directing the defendant to pay to the claimant her 1/2 basic salary and full allowance, utility, and transport allowance due to the claimant from August 24, 2007 to October 20, 2008, the period of frozen salary account for 15 months in the sum of 2,319,866 naira 55 kobo. The claimant is directed to pay. The claimant is also directed to pay the defendant is also directed to pay the claimant the sum of 3 million naira as compensation for illegally freezing the account of the claimant for 13 years. Judgment sum shall attract 10% interest, simple interest per annum until this is fully liquidated. Business is entered accordingly, and all parties shall bear their respective cost.
We thank the court for the well-considered ruling, despite the serious flu. We want to also wish the court a speedy recovery from this
Thank you.
very serious infirmity.
Thank you.
My Lord, we want to appreciate your diligence in trying to write the judgment and delivering the judgment. We're not particularly too happy because we kept stressing that the fraud as alleged was not.
It's okay, please. I've already done my part, please.
As the court pleases.
Anything you want, you can go on appeal.
Okay,
Yes.
my Lord.
Yes, you can go on appeal.
Okay.
Mr. Ambrose, the only thing that I granted the claimant was your action of freezing her account for 13 years. The 2.13 million naira and the damages. That's the only thing anybody that's not satisfied, you can go.
Yes, my lord. We noted that
yes.
You know, in our own situation, we did say that the claimant was able to access the account in the period because she withdrew some amount.
No, it's okay. I've already made my my findings. If you have any grievance, you can.
As the court pleases. As the court pleases.
So, I think that's all for this case, and I wish you well.
Thank you very much.
Mr. Sunday. Mr. Sunday.
My Lord, I wish to leave.
Eh?
I wish to leave.
You can leave. It's granted. Thank you.
As the court please, I also apply to leave.
Thank you, Mr. Ambrose. You can leave. Thank you.
As the court pleases.